My lord, I will not trouble to my lord. I got a division bench judgment saying that my lord, the Panchayat authority cannot issue my lord this certificate. Only the civil court may hand over.
Where is Mr. Hallar?
My lord, I informed him when I was. Second page, first page is the can for my lord. Condonation delay. Third page is appropriate. Third page, my lord. Third paragraph from bottom. Second paragraph starts from second paragraph. Not only upon very small judgment, but effective. In the Act, there is no provision. In the Act, there is no provision. Only competent civil court can give this declaration.
Service has been affected, no?
Yes, service has been affected. Yesterday, he appeared. Straight appeared.
That is appearing under the heading for orders. By the present writ petition. By the present writ petition, the petitioner or seek for quashing of the resolution dated 30th May 2023 taken by Gram Panchayat, respondent Gram Panchayat, within bracket annexure P4, declaring the petitioners and private respondent as heirs of late Rustam Sheikh. Rutam hoye gache. Rustam. What is the name of the father? Rustam. Rustam. This is Rustam Sheikh. Rustam.
ঠিক আছে জাজমেন্টটা দিয়েছো
আমি দিদি পরিষ্কার বলে দিই
আরে ভাই আমি আর কিছু বলছি না চলো কি করছো সেটা সাইড করছো
সেটা সেই দরকার resolution is at my lord page 23.
Petitioner contains that
Hey, attorney.
গুলোতে গেলে বিলে আরো জাজমেন্ট গুলো এনেছি ম্যাড্রাসে
ম্যাটার্স কি বলবো আমাদের
ডিভিশন
his father, namely Rustam Sheikh, died on 21st June 2022. Now, the mother of the petitioners, petitioners, predeceased their father. The father of the petitioner died leaving behind his only two sons, namely the petitioner's hearing. Upon death of the father, the petitioners applied for obtaining the death certificate from Tenkaraipur Balumati Gram Panchayat. And death certificate was issued by Sub-Registrar Birth and Death Gram Panchayat Teniapukur, Balumati on 26th July 2022. On the date the petitioners went to collect the death certificate of their father, they came to know that the private respondent, Muhammad Saharab Sheikh, has applied for a legal year certificate, claiming himself to be the only legal heir of deceased Rustam Sheikh. The petitioners lodged, petition number 1, lodged a complaint on 5th January 2023 before the local Gram Panchayat against the claim of the private respondent. However, by resolution dated 30th May 2023, the concerned Gram Panchayat has declared the petitioners as well as the private respondent, both has been declared as the legal heirs of late Rustam Sheikh. The private respondent has no connection with the father of the petitioner.
ওই ইস্যুটা করে নিচ্ছে, ওইটা তো প্রবলেম হয়ে গেল। প্রাইভেট
Being agreed by the
নেই, এটা করতে গেলেই তো তাদের
action of the local Gram Panchayat, therefore their action. The petitioner has preferred the present writ petition seeking for quashing of the resolution taken by the local Gram Panchayat dated 30th May 2023, declaring the petitioners and as well as the private respondent as the legal heir of late Rustam Sheikh.
Including its, my lord, consequentials. Including its consequentials. It has been stated in the
As well as its consequences. Mr. Uday Narayan Betal, learned advocate for the petitioner, submits that the Gram Panchayat has got no authority to issue legal year certificate. It is only the civil court which can,
para 14, my lord.
which upon para
14.
which can only
অবজেকশন তো ওটা পাস করতে হয়েছে
হুম হুম
অবজেকশন তো ফাইলটা নিয়ে আসলাম দিতে করতে না
দরকার নেই।
পাস করে দিতে
হচ্ছে
which can
বল বল
earn legal year certificate.
ওইটাই
ও দিচ্ছে না পাস করে দিচ্ছে
He seeks for quashing of the resolution dated 30th May 2023. Despite service, none appears on behalf of delivered the Pradhan Tinkaraipur Balumati Gram Panchayat. The respond number 6
6, my lord.
and private respond number 7. Mr. Pankaj Haldar, learned advocate for the state, also submits that the provisions of the West Bengal Gram Panchayat 1973 does not authorize the local Gram Panchayat for issuing any legal year certificate. Acha, owner submission, he relies on petitioner submission, he relies on the decision of this decision honorable division bench passed in MAT 498 of 2018, Lakhon Bointo versus State of West Bengal and others. 98 of 2018.
লিখে নাও।
দিয়েছে তো। এটা হচ্ছে
The only issue which has fallen for consideration is whether the
Recent
Gram Panchayat has got any authority to issue
Italy
legally a
certificate.
certificate. The Honorable Division Bench in Lokhan Boindas Tupra in the similar circumstances observed as follows. এখান থেকে এখানে এই অবধি এটাও নিয়ে নেবে নিজে। In view of the above, it is found that the local Gram Panchayat has got no authority to issue legally a certificate. Accordingly, the resolution dated 30th May 2023 passed by respondent number 5. Tinkapadi Jayokar Dekaname, Balumati Gram Panchayat is hereby set aside.
Grateful, my lord.
Writ petition being number such and such is accordingly disposed of.
My lord, the resolution and its consequential steps.
Only one submission before us.
And its consequence.
Since your lordship has set aside the resolution, whether the private respondent in the actual legal years or not, that part has not been decided by your lordship. Otherwise, my lord, it will be face the consequence. I have got my lord, the certain instruction from the BDO. Both are the legal years. So now issue before your lordships whether the panchayat has any authority to issue the legal year certificate or not.
Parties are at liberty to approach the competent court.
No, my lord. These are
Yes.
my lord, not to competent court. There is the subsequent after division bench judgment. Subsequent, my lord, the notification has come that my lord, this is the press for issuance of the my lord, the legal year certificate. You have to submit an affidavit. Then and proper inquiry to be conducted by the jurisdictional my lord, the block development officer. Then the matter referred to the district magistrate. The collector is the legal year issuing authority. So now, if your lordship particular held directing to approach before the civil court, then the subsequent the circular which has been issued by the government, then that circular is required to be
This
considered.
circular is are binding. This
My lord, this
certificate cannot.
because of that, unless and until that circular is set aside, still it is in force.
What type of
My lord, this I'm not produced. So far, your lordship has decided the Pradhan has no authority. I agree. Because of the law does not power given to the Pradhan to issue the legal year certificate or the panchayat. But the subsequent consequence, who will issue the legal year certificate? Succession is the one part that the civil code is the competent authority. So far the legal year certificate is concerned. Otherwise, my lord, everybody will face the consequence passing by this order. In a case of the retirement benefits, you go approach before the civil court, obtain the succession part is one thing. Legal year certificate, otherwise your my lord, the pension will not be.
difficulty?
This is the difficult my lord, whole issue. That's why the circular has come.
No, my lord. This
Judgment
context
delivered
of
in
this-
2018. Now the circular has come in 2022.
My lord, the circular can
My lord,
override the effect of a law.
That
laid
there
down by
has
the
to be
court.
challenged.
My lord, not only that.
Well, this
my lord,
then I leave it to your lordship. Because of that, it is not his problem. Problem in whole, my lord.
Well,
Because of that,
difficult-
everybody. will
I
face that
understand what
control
Mr.
by passing this order.
My lord, I understand, my lord, what Mr.
Issue is Pradhan
Haldar is
authority. That is
Mr.
the
Haldar is
settled law.
submitting. I understand where
He
there
will
is
also face the consequence.
no,
in future.
where there is dispute, even the circulars will not help. Where there is no dispute, all the heirs by affidavit say that we are the heirs. On the basis of the act, the circular may follow. But when there is a dispute, the non-authority other than the competent civil court can decide, because no law is there other than the succession act.
No, succession is one part, legal heirs is another part. Mala, the succession
Legal-
is
my
the
lord,
right of your property.
But then nobody has come up for quashing of the notification.
Yes.
Same time you say that this cannot be a process.
Proceed.
Even
I
my
can
lord,
say, but the
From
lordship.
your end before the government that this cannot hold good. The Advocate General can very well move before the government that, well, why this sort of notification has been issued.
Well, this notification has been issued because of the fraud. In a case of the mutation case,
Hmm.
somebody else, that is the problem, my lord. It is also face the problem regarding the pension benefit, retirement benefit.
Oh.
So, my lord, this part has to be, otherwise everybody will go approach before the civil court. Authority will take this advantage, my lord.
No.
So, no,
Competent civil court will decide,
But
my lord.
liberty কেটে দিন।
that is my lord, liberty to my lord, before the appropriate forum. That is the sufficient. Appropriate forum, maybe it is the, my lord, the civil court, or before the, according to rules or law, whatever, my lord, issued by the authority concerned.
In
My lord, this is
respect-
not,
my lord,
I have
in,
not.
my lord, in respect of immovable property, no succession is required as per the Indian Succession Act.
Yeah.
In respect of movable property, succession is required. And my lord will astonish that the term legal heir certificate in Indian law, my lord, will not find any definition of, my lord, legal heir certificate.
Approve the appropriate forum.
Yes, ma'am.
Appropriate forum.
Forum, grateful to us. That is everybody will
Everybody.
face,
Yes,
nobody
yes,
will
yes,
face
yes.
the problem.
Grateful, my lord. My lord, along with its consequential steps.
এটা কতটুকু সমান?
Grateful, my lord.
I'm led by Mr. Subhosej Chatterjee, Lordship. He is on the way to come, Lordship. On the last occasion, Lordship was pleased to pass a direction upon the respondent that to submit a report. And in the meantime, I was also directed to deposit the court fees. I have deposited the court fees to the department, Lordship. And it is reflected there in the Lordship server that the court fees has been deposited.
Okay.
So,
Yes. What is your instruction?
My lord, on 18th September, there was a meeting I had conducted with the Gram Panchayat as well as the Lazy and I have advised them to increase the minimum amount, a certain amount, not up to the 1,000, my lord. But the Lazy do not agree to this proposal and they insisted that they will pay only 300 rupees. My lord, they got the shop in the year of 2008 against 300 rupees. At that point of time, the rent was there, my lord. And today it is 2025.
I dispute, Lordship.
Correct. Not 300. They say that 300 plus increase of 5% every successive 3 years.
My lord, there is no value of 300 rupees as on date, my lord. That amount is only the panchayat is collecting from the leasee for the development of the panchayat area, my lord.
What do you want?
It's up to you, my lord.
Can the
How I
party?
can decide?
No, parties can go out of beyond the clauses written in the lease deed.
No, my lord, I am not asking to go beyond the clauses, my lord. I am asking there might be a mutual consent between the parties. At that point of time, 300 rupees was a nominal amount, but today 300 is nothing, my lord, as on date. 15 rupees after 3-year increment, my lord.
May I submit, Lordship?
Yes.
So since, Lordship, the petitioner was initially a roadside encroacher, admittedly, Lordship, in order to rehabilitate the petitioners, the Panchayat Samiti adopted a scheme itself by funding their, Lordship, the own fund. In order to rehabilitate and thereafter, Lordship, the work as well the room that was provided to the roadside encroacher, that proposal was given to the petitioners. And Your Lordship, petitioner was agreed to the proposal given by the Panchayat Samiti. They have, Your Lordship, remove all their shop. They agreed to, Your Lordship, shift in the room that was given by the Panchayat Samiti. Panchayat Samiti conduct a lottery. The petitioner participate in the lottery and obtain the room. But Your Lordship, the purpose of the purpose to allocate the room by the Panchayat Samiti was, Your Lordship, to empower the youth. As well, Your Lordship, that too, Your Lordship, to provide, Your Lordship, work and to set up a business. Monetary value is not the factor here in this matter. So that was, the Lordship, the agreement made between, Your Lordship, Panchayat Samiti and the petitioner in 2013. And there was also the specific clause that the rent will be increased after every 3 successive years. That was, Your Lordship, the condition that is given, Your Lordship. My only
My lord, being a BDO, I advise both the party to come on a conclusion which might be very helpful to the lazy as well as the Gram Panchayat, my lord. I am not asking to pay 1,000 rupees per lazy. It might be 500, it might be 400, it might be 600, but there must be a mutual understanding. I never asking them for 1,000 rupees per shop, my lord.
Okay.
But not 15 rupees per 3 year, my lord.
Presentation.
Representation, Your Lordship, in page number 190. My only prayer is that, Your Lordship, to pass a direction upon the respondent authority, that to, Your Lordship, to adhere the agreement that was made, Your Lordship, in 2013.
They will consider your representation. That is your prayer in the representation.
Yes, Your Lordship, I prayed, but
Let him pass an order. What should be the by the present petition, the petitioner seeks for setting aside the resolution dated 14 June 2025. What was the resolution?
resolution, Your Lordship, to increase the fare.
65 rupees to 1,000 rupees per month, my lord.
The
Page
next
number 180.
second page of my report, today's report. Resolution of the meeting held on 18th September.
All parties will agree that no other can reconsider this agreement or not. In is considered to increase the rate of exceed as the present market value. Okay. No, not this. The resolution is of 14 June 2024. 14 June 2024 resolution.
That is,
I don't have the
Lordship,
copy
that
of the
is
resolution.
my
The
first
authority
report.
inclined to provide me the copy of the resolution. And I was not the part of the meeting
This
where
is-
in which, Your Lordship, the
First report I submitted
fare
on the last
was
petition.
increased.
Here is resolution of 14th June. একটু দাঁড়াও আমাকে বলতে দাও। Second page.
Petitioner contains that
কি বলছো বলো?
petitioners contained that they were allotted rooms in the marketplace at Tridip Chaudhary Market Complex, Nauda, Murshidabad. And
এটা
a lease agreement was entered between the Nauda Panchayat Committee, yes, it is Panchayat Committee and the petitioners. As per the lease agreement, the enhancement of the rent was supposed to be increased at the rate of 5% in successive 3 years. The executive officer, Nauda Panchayat Samiti, এই যে সেটাই তো খুঁজে পাচ্ছি না। You have not annexed the resolution? June
In my
resolution?
writ petition, since I didn't have the copy of the resolution, I was not provided, Your Lordship, the copy was not provided to me.
Yeah, how have you got the
I came to
cover of
know,
the resolution?
Your Lordship,
Document?
I have annexed a notice of the, Your Lordship, the
Lordship,
pair
in
that
my
is appear in Your
earlier
Lordship,
report,
page number
second page.
188.
In my earlier report, in the second page,
Page number
neither the
188.
video nor the development block, it is there, Your Lordship.
After the meeting held on 14 June 2025, issued later on 28 August 2024, asking the petitioners to informing the petitioners of enhancement of rent to the tune of ₹1,000 per month. This is per month.
Yes, Lordship, per month 1,000.
Per month.
That was the proposal.
Being agreed by such action of the executive officer, the petitioners have preferred the present writ petition. Mr. Sobhusachi Chatterjee, Mr. Kiran Sheikh. Your name is Kiran.
Yes,
Mr. Kiran Sheikh, learned advocate for the petitioner, submits that the enhancement to ₹1,000 per month is dehors the clauses of the lease agreement. The petitioners has made a representation before the executive officer on 25th March 2025 for
Lordship, as well forwarded to the other authority. Sabriya.
কি বলো? For consideration of the rate of rent. However, the same has not been considered as yet. He seeks that the matter be relegated to the executive officer Nauda Panchayat Samiti to consider and decide the representation of the petition dated 25th March 2025. Mr. Bimal Kumar Sahil, an advocate appearing to virtual mode for the state, submit that a meeting was held with the petitioners as well as the Nauda Panchayat Samiti. However, no consensus could be reached with regard to the rate of rent. As per the lease agreement dated 16th April 2013, the petitioners, that is the lessees, were required to pay enhanced rate at the rate of 5% in successive 3 years, along with rent as described therein before the lessors. It is not in dispute that the amount of ₹1,000 is not calculated in terms of the lease agreement. In view of the above, the letter of the executive officer holding the rate of rent as ₹1,000 per month, dated 28th August 2024, is set aside. Executive officer is respond number
Respondent number, Your Lordship.
Is directed to consider
5.
No, the video.
Respondent 5.
the
Video.
representation of the petitioner. 5.
Respondent 5, Your Lordship.
Dated
Block Development
25th
Office.
March 2025. Taking into consideration the clauses of the lease agreement. Taking consideration the lease agreement dated 16th May 2013, sorry, 2013, and pass reasoned order upon after giving opportunity of hearing to the petitioners as including all interested parties. This reasoned order shall be communicated to the petitioner within a week thereof from within 6 weeks from date of communication of the order. Reasoned order is your passport. With the aforesaid direction, the writ petition being number such and such is disposed of.
May I
Let me
submit?
oblige, my lord.
Since Your Lordship, the notice issued by the BDO executive officer. So if Lordship, if the authority will consider the same, then there might be a bias on the nature of Your Lordship. Since the authority issued the same, the where Your Lordship the fare was increased, agreement was also made by the same authority, and
Authority has issued a letter without an order being passed. Now your representation has been sent for passing a reasoned order in the light of the lease agreement. Either he has to say that the lease agreement does not exist, or if it exists, he has to add it to that.
yes,
Let him pass a reasoned order, what comes up?
yes, grateful.
Let me oblige, my lord.
37 वाला डैम पर हाँ for the petition.
পুলিশ শুধু থাকবে কাউকে কোনো মোশন করবো ব্যাস যেগুলো দিয়ে দিয়েছি আমি ডেট আর কিছু না। ঠিক আছে অক্সিজেন আছে না আর রিটার্ন কপি কোনগুলো আছে কটা আছে দেখে নেবেন এটা আমি ভেবে রেখে নিই নেমে দেখি আর একটু 24th September. Yes.
This is an application where the petitioner is seeking appointment under compassionate ground. On the death of his father, he is praying for appointment. His application was initially rejected in September 2023. That rejection was challenged by preferring a writ petition, and that writ petition, this honorable court hold that the application of the petitioner was rejected initially on the ground of delay submission of application. Kindly come to the rejection order at page 54. This is the first rejection by the authority. The last 2-3 lines is very important. May I, Malad?
Yes.
I am directed to refer to the above mentioned subject and to inform you that this department conveys its inability to accede to the proposal for appointment on compassionate ground in died in harness category in favor of Sri Tufan Bagdi, son of such and such, on the ground for late submission of pro forma application by the applicant more than 6 years 10 months from the death of his father, as per provisions laid down in the notifications of such and such notifications has been mentioned in that rejection. This rejection was challenged by the petitioner in a writ petition, and at the time of considering the writ petition, kindly come to page 58. This is the order passed in earlier writ petition. The first, second, third paragraph at page number 58. I am convinced that the ground of rejection is not sustainable. The ground of rejection was the delay submission of pro forma application. The delay was the authority calculated at 6 years 10 months. And in first round of writ petition, this honorable court passed an order thereby holding that the ground of rejection is not sustainable. And as such, the writ petition was disposed of, thereby directing the authority that they let the secretary, Panchayat and Rural, at page 59, the third paragraph from bottom. Let the secretary, Panchayat and Rural Development Department, Government of West Bengal, consider the application of the petitioner for his compassionate appointment on merit within a period of 3 months from the date of communication of this order. Which means, the ground of delay submission, it was set aside. That the authority was not permitted to consider the case of the petitioner once again on the ground of delay. And now the authority hold a hearing, and after hearing for the second time to the petitioner, again the authority rejected the claim of the petitioner for his appointment on compassionate ground on the same ground. Kindly come to page 60. This is the last rejection passed on 4th of December 2024. The petitioner, along with his learned advocate, attended the hearing on such and such date, and they were heard. On perusal of the relevant papers, documents in connection with the instant writ application, it has been found that the employee named Golokpati Bagdi was a Gram Panchayat Kormi of Dheka Gram Panchayat under Mureshwar 2 Development Block, Birbhum, who died in harness on 7/7/2015. Thereafter, Sri Tufan Bagdi, one of the sons of late Golokpati Bagdi, came up with a prayer for an appointment on compassionate ground. The complete pro forma application signed by him on such and such date. The authority very cleverly, they mentioned the pro forma application submitted by the one of the sons of the father of the petitioner. But cleverly they have not mentioned when that pro forma application first time submitted by the petitioner, because the authority, they admitted the fact that the pro forma application was submitted by the petitioner initially. And now they have mentioned when the petitioner put his signature in that pro forma application, which was initially submitted in 7 of October 2015. The complete pro forma application signed by him on 01/12/2020, along with the 3-man committee report and other relevant documents, reached this department with a memo number such and such, dated such and such, of the additional director. Although it has been observed in the solemn order dated 4th of September 2024, it is the order of the first writ petition. Although it has been observed in the solemn order dated 4th of September 2024 with reference to an annexure of the writ petition that a pro forma application of the petitioner was forwarded to the District Panchayat and Rural Development Officer Birbhum by a memo number such and such dated 24th November 2015 of the Block Development Officer Mureshwar 2 Development Block, Birbhum. Yet, no copy of that memo of such and such number and date, along with any document, is found to be attached with the official records which had been received at this department. All the communications between the department, the superior authority of the department, they admitted the fact that in October 2015, the petitioner submitted his pro forma application. But now, with some of the department in between, they have lost the documents from their custody and the entire blame upon the petitioner, and now he is suffering that he has not submitted the pro forma application within time. And thereafter, with the official records which had been received at this department. However, it is also noticed that the reference of the said memo has been reflected in the forwarding letter of DP and RDO Birbhum addressed to the Commissioner, Panchayat and Rural Development, with its memo number such and such dated 13th of July 2018. In turn, on possessing the matter, the proposal along with its all documents was returned to DP and RDO Birbhum with a memo number such and such dated 27/12/2019 of the Deputy Director, Panchayat and Rural Development, requesting to resubmit the dated and complete pro forma application with fresh three-man committee reports by drawing attention to some definitive documentary as well as informative shortcomings that rendered the proposal erroneous and not fit for evaluation. Later on, several correspondences has been exchanged between the department and the DP and RDO Birbhum regarding submission of relevant documents. The proposal, when it finally came to this department dated 11 of January 2023, contained the complete pro forma application dated 01/12/2020, furnished and signed by the petitioner, about which the petition has remained silent. This complete proposal has accordingly been processed as per existing norms, and in course, the proposal for appointment on compassionate ground in respect of the petitioner was rejected. Via this department, memo number such and such dated 4th of August 2023 on the ground of late submission of the pro forma application by the applicant. Now the ordering portion, my lord. It is a fact that the petitioner had submitted the pro forma application in complete manner and signed by him as late as on 01/12/2020, while the employee died in harness on 07/7/2015. The proposal have been processed in the department with reference to this complete pro forma application dated such and such, following extant norms, and was rejected on the ground of late submission of the pro forma application. As there is no document, well, this is very important, as there is no document available on record in this department corroborating the submission of a non-defective or non-erroneous pro forma application by the applicant on a prior date, hence no merit is found to consider the application of the petitioner eligible for grant of appointment on compassionate ground. Thus, the prayer of the petitioner is liable to be rejected and is hereby rejected. Now, when this court in earlier petition setting aside the order of rejection on the ground of delay submission of the pro forma application, which means the court already held that application submitted by the petitioner within time. Now again the authority holding the same point that the pro forma application filed by the petitioner at delay stage again rejected the claim of the petitioner without considering the other aspects as laid down in the notification as well as the statute, whether he is eligible for getting the appointment under compassionate ground or not. Because for that reason, the authority, they are asking for several documents, the three-man committee report, whether he is still that financial hardship is with the petitioner or not, whether he is still lying with that family or he is having other sources of income, anything, any other terms for consideration of his appointment. Not a single ground has been considered by the authority, only the ground that delay submission.
Yes.
I have relied on a report, my lord, in the form of an affidavit, my lord. And my lord, if your lordship kindly takes it up, my lord, admitted, it's an admitted fact that Act 12/2020, my lord, 2020, my lord, this pro forma application finally, my lord, signed and submitted. My lord, if your lordship kindly takes page 3 of my report, paragraph III.
Page 3.
Yes, Lord, may I place, Lord? It is stated that the petitioner herein, being one of the son of the deceased employee such and such, came up with a prayer for an appointment on compassionate ground. The complete pro forma application signed by the petitioner himself dated 1/12/2020, and the government employee has signed the same on 1st December 2020, along with three men Screening cum Inquiry Committee report dated to a 22nd August 2022. And other relevant will reach the Panchayat and Rural Development Department, video memo number such and such, 11 January 2023 of the Additional Director, Panchayat and Rural Development. Then below paragraph III, Roman 3, it is stated that although it has been observed in the writ petition that a pro forma application of the petitioner was forwarded to the DPRDO, being Bhaile memo being such and such of the BDO, Mahureshwar, yet no such copy of the memo being such and such along with any document is found attached with the official records which had been received at Panchayat and Rural Development Department. However, it is also noticed that the reference of the said memo such and such has been reflected in the forwarding letter of the DPRDO addressed to the Commissioner of Panchayat Rural Development, video memo number such and such. In turn, on processing the matter, the proposal along with all documents was returned to the Panchayat Rural Development Officer, Birbhum, video memo number such and such, 27 December 2019 of the Deputy Director, Panchayat and Rural Development, requesting to resubmit the dated and complete pro forma application with fresh 3-man screening committee inquiry report by drawing attention to some definitive documentary. But I am harping on this, to some definitive documentary as well as informative shortcomings that rendered the proposal erroneous and not fit for evaluation. Later on, several correspondences were exchanged between the direct DPRDO and the Panchayat and Rural Development Directorate regarding submission of relevant documents. The proposal, when it finally came to the Panchayat and Rural Development Department dated 11 January 2023, contained the complete pro forma application dated 1st December 2020, furnished and signed by the petitioner, about which the petitioner remained silent. So, my lord, if he has submitted the complete pro forma, my lord, application, then, my lord, what prompted him to sign again on, my lord, 1st December 2020? It means that he had not submitted, and on that score he was silent. Previously I have given, if he has, my lord, your lordship would be surprised to see that, my lord, if he has submitted one pro forma application, he must possess, my lord, a copy of that same. Neither in the previous writ petition, not in this writ petition that has been annexed. Only a forwarding letter, proposal of 2015, that has not been annexed. Only a forwarding letter of the video that has been
You
annexed.
said that in 15 they have submitted a pro forma.
Because that pro forma application has not been annexed, which she claims to have been signed,
It is admitted.
Yes,
which she claims have been signed in 2015. That has not been annexed.
yes,
And, my lord,
from 35
and,
to
my lord,
38.
and, my lord, again he has signed the pro forma application on, my lord, 11 January 2020, my lord, 1st December 2020.
If it is not annexed, then how could the court get the reference number, memo number and all?
My lord.
In the order itself, it is stated that on such
Yes.
and such. Thereafter, the court holds that there is no delay.
My
Lord,
lord.
in
I'm
the
deeply obliged to
in
your
the
lordship.
first
There is
round of writ petition, my lord.
Here's from Annexure P3, page 58.
Yes.
My lord.
You say that it was not annexed either. Annexure P3 of the writ petition, then memo number such and such, block development of forwarded the same.
This is that the same memo which has been annexed in this writ petition, not that pro forma application which he claims to have signed in the year 2015.
Memo, it's not my memo.
Pro forma application.
Memo of the BDO, my lord. If your lordship kindly comes to the ultimate paragraph of page 58, it appears from annexure P3 of this that by a memo such and such of the block development officer forwarded the
Pro forma
application.
to the petition.
So that he must possess that copy of the pro forma application. That has not been annexed. Our case is that at that point of time, no pro forma application has been submitted that were found available in our department. Only when we said in terms of the order of this honorable court to revisit the issue, then, my lord, only he has submitted the pro forma application on 1st December 2020.
Where is that letter of the block development officer?
If your lordship kindly takes, my lord.
There was no such pro forma.
This is the pro forma application I have annexed R1. Your lordship kindly sees. Has your lordship got it? My lord, page 9.
Page 14.
This is the first page of pro forma application, and page 10 bears the date, my lord. Bottom, my lord, 1st December 2020.
Page 46.
Bottom, my lord, page 10. This is the pro forma application. Complete pro forma application.
The block development officer has forwarded. This is R2 of your.
My lord, I'm deeply obliged to your
Yes,
lordship.
this document will not dated 24/11/2015 was read on in the previous writ petition, but no pro forma application which she claims to have signed in
Forget
20.
about the pro forma.
Yes,
It also records that along with a report of 3-member committee.
lordship, my lord.
3-member committee is not produced by the petitioner. And if you have misplaced that 3-member committee report, you
I'm
cannot
deeply
say
obliged to your lordship.
3-member committee.
I'm
How can
grateful
he
to your lordship.
inquire without there being a
But
proper
our
inquiry?
admitted position, our case is that we have received a complete pro forma application in pursuance to our queries and
then-
letters.
Then the 4th August 2023 holding that there is 6 years of delay, and thereafter in 2024 court passes an order that there is no delay. What remains then?
Because court passed an order on previous
Suppose a
occasion
rectification is
to
made.
revisit the
subsequent
matter
to
on
the
merit.
order.
To
Suppose
revisit the matter on merit.
rectification has been made subsequent to passing of the order. That person who is signing, he puts a date. Now that date becomes the date of the application.
Because
And the
court
court has
passed an
already
order
made-
4th September 2024.
Yes.
Yes.
Yes,
And 2023, the department says that there is 6 years of delay.
on belated submission.
It have been considered by the court, and thereafter the court in the writ petition, previous writ petition,
So
observes
kindly
that
see
there
the
is-
ordering portion. Kindly see
My
page
lord,
59.
kindly read from
Penalty.
the very first line of that order, my lord.
তোর সময় আমি কিন্তু বলিনি।
না, sorry, আমি বলে দিচ্ছি।
Milord kindly sees, Milord page 59, penultimate paragraph of the order, Milord.
Yes.
Let the Secretary Panchayat and Rural Development Department, Government of West Bengal consider the application of the petitioner for his compensation upon on merit. Milord, we have asked to deal this application on merit without previous observation on merit within a period of 3 months. So we did it on merit, Milord. Revisit the issue on merit. And on the strength of a circular, Milord.
There is no findings with regard to merit.
Right.
You say that there is late submission, which has
Well-
already been decided by the court.
I'm grateful to your lordship.
Okay. Asu.
The very first line of that order, my lord.
Let us say.
Despite the order dated July 31st, 2024,
Who will process this? Who will process this? Who will take the further steps?
That authority who has passed the order, Milord.
Secretary. So he will reconsider and revisit the
Yes,
issue
yes,
with
yes.
regard to the previous order passed in the writ petition.
Lordship, Milord. Lordship. And upon considering all relevant facts in accordance with law, upon giving hearing to all the stakeholders.
Yes.
my lord, kindly this time
Well,
specifically mention that ground of delay submission,
Has already been decided.
my lord.
Very hard. Okay. Good. By the present writ petition, the petitioner seeks direction upon respondent number 4 to issue appointment letter in the name of the petitioner on the ground of die in harness category by cancelling and setting aside the rejection order dated 28 November 2024. আচ্ছা রেসপন্ড নাম্বার 4 এর ডেজিগনেশন একটু দেখে নেবেন সিনিয়র ডেপুটি সেক্রেটারি অর্ডারটা দেখি কি পাস
My lord, may I be permitted to say one more thing? My lord, in the second time, they have rejected my claim from the very beginning on the ground that I have submitted the application delay. As such, I am not in such zone of consideration for getting appointment or to consider my claim as an for an appointment under the ID in harness category. But which means, my lord, as I am not eligible, or if I am ineligible on the ground of delay submission, and there is other grounds for considering the case of the ID in harness category, my lord. In the case of writ petitioner, my lord, then the petitioner is otherwise eligible except the ground of delay submission. And if that ground of delay submission is not there, then the petitioner is very much eligible to get the appointment under
No,
compulsion ground.
they have to decide.
Because they have not considered those grounds, my lord.
They have to decide on the inquiry report also.
Yes,
Huh?
my lord.
Whether requirement is there, they have to decide on that. Their notification says so. So they should be given an opportunity to decide on that.
Yes.
Apart, leaving behind the delay.
But
part.
except those documents, my lord, they have again
Then
decided
there
on the
is
same
no
ground.
deal.
My lord.
The other aspect they have to deal with. The petitioner's father was a Gram Panchayat Karmi of Dheka Gram Panchayat under Moireshwar 2 Development Block, District Birbhum. While in service, the father of the petitioner expired on 7 July 2015. After rendering service for a period of 35 years, 6 months, 19 days. The petitioner made an application on 7 October 2015, praying for appointment on compassionate ground. The application of the petitioner was forwarded to the District Panchayat and Rural Development Officer, by the Block Development Officer, Moireshwar 2 Development Block. This is second round of litigation. Next para. The application of the petitioner was rejected by Assistant Secretary to the Government of West Bengal Panchayat and Rural Development Department, predates later dated 4th August 2023. Being agreed by such action, the petitioner approached this court by way of a writ petition being number WPA 23236 of 2023. Next, the aforesaid writ petition was disposed of on 4th September 2024, directing as follows. Pursuant to such direction passed in the aforesaid writ petition, the prayer of the petitioner for appointment on compassionate ground was rejected by respondent number 4, Senior Deputy Secretary to the Government of West Bengal Panchayats and Rural Development Department, as follows. Ordering portion এখান থেকে দেবেন, হ্যাঁ? Page 60 number 60. The petitioner in the present writ petition challenges the subsequent order of rejection of respondent number 4 dated 28th November 2024. Ms. Chui Datta Chakraborty, learned advocate for the petitioner, submits that the application of the petitioner has been rejected on the sole ground of late submission of pro forma. However, the said aspect had been set at rest by the previous order of this court passed in WPA 23236 of 2023, wherein it has been categorically observed that there was no delay in making the application. He seeks for setting aside of the impugned order. On the contrary, Mr. Santanu Kumar Mitro, learned senior government advocate appearing for the state, submits that after passing of the order in the writ petition being WPA 23236 of 2023, sorry, na, the petitioner was directed to submit complete pro forma application with phrase committee report since there was some documentary as well as informative shortcomings which rendered the proposal erroneous and not fit for evaluation. The complete pro forma was submitted before the concerned authority on 1st December 2020. The death of the employee having taken place on 7th July 2015 manifests that there is a delay in submission of the pro forma. Therefore, as per the notification of the government, the order passed by respond number 4 could not be interfered with. Para. This court, previously the prayer of the petitioner was rejected by the Assistant Secretary to the Panchayat Rural Department on 4th August 2023 on the ground of delay of 6 years, 10 months. In the writ petition, being WPA 23236 of 2023, it has been observed by the court that there is no delay in making the application. The court directed the Secretary Panchayat Rural and Secretary Panchayat and Rural Development Department, Government of West Bengal, to consider the application of the petitioner for his appointment on compassionate ground on merit. On going through the impugned order, it is found that once again the application of the petitioner for appointment on compassionate ground has been rejected on the ground of late submission of pro forma application. Such being the position, the impugned order is liable to be set aside. Accordingly, order dated 28th November 2024 passed by Senior Respond Number 4, Senior Deputy Secretary to the Government of West Bengal, Panchayats and Rural Development Department is set aside. He will consider. 4 will consider. And the Secretary. Secretary.
8 weeks, my lord. 8 weeks.
Secretary will consider.
Secretary
Not
will consider.
Secretary is respond number.
Respondent.
Four. My lord, Secretary is the respondent number 4, my lord.
4. 1. Secretary is 1.
Yes, 1. 4 is the senior deputy secretary.
Respond number 1. Secretary is directed to consider the prayer of the petitioner for appointment to compassionate ground. Appraise within a period of 6 weeks from date of communication of this order.
Lord, in accordance with relevant rules and regulations.
My
In
lord,
accordance with relevant rules and regulations, the London advocate for the petition directed to communicate this order. Read petition disposed of.
I'm getting to you. 6 weeks.
38 we are, I appear on behalf of the state respondents.
I appear with the private respondent. My lord, I am appearing on behalf of the Hooghly Jilla Parishad, my lord.
My lord,
Item number 30.
my lord, in this matter,
Then
initially, my lord, for illegal construction of a D+4 storage building, my lord, we had approached before this honorable court for demolition of that building, my lord. Now, my lord, this honorable court was pleased to dispose of the writ petition. My lord may find the order at page number 19 of my writ petition. The order starts, my lord, the relevant portion is at page number 27. My lord may find in the last but one paragraph, may I place, my lord? In view of such conduct, my lord has found it.
Page 19.
Page 27, my lord. Page 19 is the starting of the order, my lord. I am referring to page number 27.
Yes.
Page number 27, my lord has got it. My lord, I am referring to last but one paragraph, my lord. In view of such conduct. Internal page 9, my lord.
Yes.
My lord, in view of such conduct, this court, my lord has got it.
Before my learned friend proceeds further, my lord, there is a preliminary objection. There is another writ petition pending. Where, my lord,
My lord, I will come to that. I will come to that.
preliminary objection, let me take it, then you address it. Yes, filed another writ petition challenging the maintainability of the proceeding before the Jilla Parishad, the secretary. That writ petition has been admitted, affidavit pending. And this writ petition is asking for an early disposal of the same proceeding. So two petitions are not contradictory and not diametrically opposite. So those two should be heard together, because if the previous one is pending, my lord, possibly this cannot.
My lord, the division bench has already, in a contempt application, has already decided that, my lord. My lord, I will come to that. I will satisfy your lordship on that score also, my lord. I have not suppressed. I have not suppressed any facts.
Suppression. I am saying those two cannot go hand in hand.
My lord, I will come to that. I will satisfy your lordship.
Saying that the proceeding is not maintainable, it is admitted, and in this proceeding, he is participating and saying early disposal. Those two are.
My lord, I will come to that, my lord.
That proceedings. That both cannot. This is the order of the other writ petition. He has stated. I am not saying it's suppressed. Mr. Banerjee will not suppress. I have full
My lord,
confidence.
in one pending proceeding, he is saying that the respondent number 3 does not have the jurisdiction to hear out this matter. And in the present proceeding, my lord, he is saying that
is not well founded and has rejected my contention already, and that has been annexed to the writ petition, my lord.
But the earlier writ is still on pending.
Oh, yeah.
Challenges the jurisdiction, then how can he ask for early disposal of the same authority?
But the same authority.
He has stated in paragraph 16 that previous one is pending. Suppression আমি বলছি না।
না ঠিক আছে, আমি জানি পয়েন্টটা তুমি তুলবে, আমি জানি। My lord, may I satisfy your lordship, my lord? Now, my lord, page number 27, internal page 9, my lord. My lord has got it. Now, my lord, last but one paragraph, my lord. In view of such conduct, this court finds serious laches in the action of respondent number 5, that is Pradhan of Shingur Gram Panchayat 1. And since this court has already come to a finding that the building of the private respondent numbers 10 and 11 have been erected in contravention of the provisions of sections 23(1) of the said act, the court, in exercise of its plenary power, thus directs the SDO Chandanagar district Hooghly to initiate an appropriate proceeding under section 23(5) of the West Bengal Panchayat Act 1973 within a week from day, within 3 weeks from date of the communication of this order against the private respondents number 10 and 11 for illegal construction of a four-story residential cum commercial building over plot number so and so, Khatian number so and so, Mouja Jolaghatta, JL number 79, PS Shingur, district Hooghly. Now, my lord, the next paragraph. Both the writ petitioner will appear before the SDO Chandanagar. My lord, paragraph number 22 is important. The SDO Chandanagar district Hooghly is further directed to give an opportunity of hearing to the petitioner and the private respondent numbers 10 and 11 and or their learned advocates, and upon hearing shall pass a reasoned order positively within August 31, 2024. So, my lord, this my submission is the honorable court has already come to a finding that the building is illegal. The construction of the building is illegal, and it has been built in and it has been constructed in contravention of section 23(1) and 23(5) of the Panchayat Act. Now, my lord, they have challenged this order. My lord will kindly comes to page number 32 of the writ petition, my lord. Now, my lord, the operative portion is at page number 36. In view of the aforesaid discussion, we do not find any reason to interfere with the order impugned. Appeal is accordingly dismissed. And my lord, paragraph number 18, my lord will see, we are informed tomorrow has been fixed for hearing before the SDO concerned. We direct the SDO Chandannagar to Hooghly to fix the hearing on 3/9/2024. And the proceeding was directed to be concluded within 30/9/2024. Now, my lord, SDO Chandannagar took up my matter for hearing. Now, my lord will kindly come to page number 60 of the writ petition. 60, my lord. My lord, here, my lord. Now, my lord, SDO takes up my application for hearing under the orders of the High Court, and SDO passes an order directing that I am not the authority, Zilla Parishad is the authority. My lord, the operative portion is at page number 63, long order 63. Huge order, my lord, needs not to be troubled, my lord, 63, last paragraph, my lord. My lord has got it. Hence, the appropriate authority is Zilla Parishad to take action when there is contravention of provisions of subsection 1 of section 168, which means that when there is issue relating to permission for construction of any structure or building of height more than 6.5 meters of the ZP concerned is the appropriate Zilla Parishad concerned is the appropriate authority under subsection 6 of the 160A of the West Bengal Panchayat Act 1973. Therefore, the entire matter is hereby forwarded to the executive officer, Hooghly Zilla Parishad, and District Magistrate Hooghly, with request to kindly refer to the facts stated above along with copies of all the documents submitted by the petitioner respondents, BDO Shingur, that is BDO Shingur, and the Pradhan, Shingur 1 Gram Panchayat, for appropriate action in this regards. Let the copy of the reason of order be communicated to all concerned. Now, my lord, the proceeding was forwarded to the Zilla Parishad, and my lord, subsequently, my lord, because my lord, I was aggrieved by this order, since my contention was that at that point of time that unfortunately I lost on that point, that SDO is the authority, since this honorable court has considered all points, and Zilla Parishad has already contested the proceeding, so SDO should hear the matter. So on the order that my lord has read, there also I put an objection before the SDO that you are not that you are the authority. And my lord, when it was remanded to the Zilla Parishad, 1311, page number 91, my lord kindly comes. (13/11/2024) order. There also in Zilla Parishad also I have raised this issue that SDO is the authority, Zilla Parishad is not the authority. Zilla Parishad turned down my contention and said that your preliminary objection is unsustainable, hence rejected. Now, my lord, I challenged both the orders. My lord has seen the last SDO's order and this 13/11/2024 Zilla Parishad order. I have challenged both the orders in two different proceedings. First of all, I filed a contempt application with regard to the appeal that directed the SDO to dispose of the matter on two grounds. Since the time period was expiring, 30/39/2024 was the time period, it was expiring, and since the order contravened, since I needed an interim order before the SDO also, was because the Zilla Parishad was proceeding with the matter, I challenged that matter before the writ court. Now, the writ court has, my lord, Mr. Banerjee has handed over an order before your lordship, my lord. The writ court has refused interim stay and has directed affidavits. And my lord, the contempt application was taken up for hearing by the Honorable Division Bench. My lord, page number 92.
What is the order?
Page number 9, my operative portion is at page number 94, my lord.
Yes.
Now, my lord, page number 94, my lord, kindly comes up the observation of the court. Upon perusal of the record, it appears that in compliance with the direction passed by this court, the SDO Chandannagar had initiated the proceedings within the stipulated time. However, in view of section 160A6 of the West Bengal Panchayat Act, the SDO was of the opinion that Jila Parishad is the appropriate authority to deal with the matter. Accordingly, by order dated 9/9/24, the SDO referred the matter to the Jila Parishad. Consequently, Jila Parishad is presently examining the said matter. It is always been the intention of this court to ensure that the issue under consideration is adjudicated by the competent authority in accordance with law, be it respondent number 1 or 2. It was the SDO or Jila Parishad. Although the respondents could not finalize the posting within stipulated period, this court is of the considered view that the delay was not intentional and therefore does not amount to willful disobedience. Further, respondent number 1 referred the matter to respondent number 2 by way of detailed order dated 9/9/24, which is the petitioner's challenge by filing a separate petition. In view thereof, this court is of the constituted view that no case of contempt is made out against the respondent number 1. Now, my lord, we have accepted this contention of the learned court and we have stopped litigating further on this issue. Now, my lord, this order, my lord will see that this was after the order that Mr. Banerjee has handed over to your lordship. This order was after that order. So, my lord, in the writ court also, challenging the jurisdiction in the writ court will also not any to any benefit of me. Now, my lord, I will have to accept Jila Parishad as the authority. And my lord, in all the proceedings that I had contested before the Jila Parishad and before the SDO, everywhere the respondents were of the objected me on the ground that no, Jila Parishad is the authority, SDO is not the authority. So, my lord, I lose on that point and I accept that Jila Parishad is the authority. Even if my learned my learned senior friend calls for that purpose, my lord, my client is also present, my lord. I am ready to withdraw that writ petition also. Withdraw that writ petition, my lord. So, my lord, I am not pressing. I am withdraw, my lord. My record that. My lord, record that. Now, my lord,
Let him withdraw. That is my sole point. Because the contempt court also not held that the order of the secretary has been challenged by him by a separate petition which is pending. So we are not interfering. Now that it is pending. He is saying that
they have not filed any affidavit till date.
Maybe secretary has jurisdiction. So today he cannot blow hot and cold. This is a court of the constitutional court. He has to make up his mind whether he wants. Because if your lordship directs him, but the petition is pending, then tomorrow he will say that the authority did not have jurisdiction if the order goes against him.
No, my lord may record my submission. My lord may record my submission. No, my lord may record my submission.
Let the writ appear tomorrow. Let him withdraw that and.
My lord may record my submission on that.
Then can he take up this matter? Because
now, my lord, after that, my lord, Jila Parishad.
He cannot blow hot and cold at the same time.
The writ petition he has challenged which order?
By both the orders.
Secretary, by which secretary has relegated the matter to the Jila Parishad. He has challenged on the ground of the SDO, where the matter has been referred. He says that no, the SDO has to decide. Jila Parishad cannot decide.
And after that, the contempt court orders comes in.
So the
contempt court has not decided anything.
No, order dated 9 September 2024, which he has challenged. It is which writ?
This is the order of the SDO by which the SDO has relegated the matter to the Jila Parishad.
Correct.
That is that writ, my lord.
31004, which he intends to withdraw.
My lord.
And this is for expeditious disposal
of the Jila Parishad.
Of the
Jila Parishad proceeding with Jila Parishad.
Since in that.
Now, my lord, Jila Parishad is proceeding with. Please, my lord, let me complete. On that,
he has taken the point that the Jila Parishad does not have jurisdiction. He cannot now say that the Jila Parishad will not be directed to expedite it. Let him withdraw.
Now, my lord, may I?
Then kindly take.
My lord, may I make out my point? Now, my lord, the Jila Parishad is proceeding with the instant proceeding, my lord. And now, my lord, I have concluded my arguments with the Jila Parishad. I have annexed that order, my lord. I will show to your lordship. I have concluded my arguments. On 3 occasions, they have taken time on medical ground. Jila Parishad has allowed that. Now, my lord, my point is that, my lord, an illegal construction, which the High Court has admittedly held to be an illegal construction, my lord, my lord,
come up. If you say that the Jila Parishad is a person, then you withdraw that writ petition. There will.
No, my lord, let the 2 writ petitions appear analogously, my lord.
Tomorrow it will appear. It is pending. Our kache to nahi mone hocche na.
My lord,
the other writ petition
is before your lordship under the hearing heading. Is before your lordship under the hearing heading, my lord.
Formal order pass na kore thike raho.
No, my lord,
order কিছু করছি না কালকে এটা affidavit
kindly pass the online order.
Online order.
Okay.
For benefit of.
Learned advocate, affidavit has been filed on behalf of the petitioner is taken on record. Learned advocate for the petitioner submits that The learned single judge, after holding that the
নাম দিয়েছি তো
construction undertaken by construction, it is G+3 or 4?
G+3, my lord.
G+3 construction undertaken by the private respondents to be illegal, directed the subdivisional officer Chandan Nagar to initiate appropriate proceedings under section 23(5) of the West Bengal Panchayat Act 1970. SDO's order is at
My lord, the SDO's order 99/2024.
page number.
My lord. My lord.
Mr. Banerjee, SDO's order is at page number?
60 কত
The subdivisional officer,
at page 63 I believe operative part.
subdivisional officer Chandan Nagar passed order
My lord,
stating
60,
that,
my lord, page number 60.
stating that the Jila Parishad is the appropriate authority under subsection 6 of section 160A of the West Bengal Panchayat Act. A contempt petition was filed by the petitioner, which has been disposed of,
Dismissed actually.
which has been dismissed, holding that no case of contempt is made out. And also observe that since the order of the SDO has been challenged in the separate writ petition, তারপর observation, it dismissed the order, dismissed the contempt application.
Just to withdraw
The
it.
petitioner submits
আর
that
কিছু কষ্ট
the
চাপাতে
hearing
হবে।
before the
কষ্ট কিছু চাপাতে
Jila
হবে।
Parishad has already been concluded. Argument concluded, Mr. Banerjee.
No, no, argument of the petition has been concluded.
No, the argument has been concluded with the Jila Parishad.
Argument has been concluded. Since there in proceedings, the petitioner has preferred the present writ petition. However, he submits that another writ petition, which has been filed challenging the order of the SDO, is also listed before this court, is pending before this court. Also, list both the parties, all the parties submits for listing this writ petition along with, what is the number of that?
WPA 31004 of
001
31004.
31004 of 2024 be listed along with the writ petition. কালকে আছে রেকর্ডটা?
My lord, at the top, my lord, kindly. My lord, because there is some urgency in this matter, because my lord has my lord may
It so happens that there are other matters which is being taken up.
no, my lord may appreciate one thing, my lord. Our illegal construction which has been declared by the High Court.
No, High Court has directed the
High Court has declared it to be illegal, my lord. That is a specific order of the High Court, my lord. I have shown to your lordship. That is the reason, my lord. Some urgency, my lord, if it subject to your lordship's convenience, obviously, my lord. It can come tomorrow at the top, my lord, kindly. So that it can
রেখে দিন তো, কালকে হয়ে যাবে।
oblige.
এটা নিয়ে নিন
কালকে এইটাও কি মোশনই লাগবে? 39
I am on behalf of the petitioner. 39.
Lordship, I am appearing on behalf of the petitioner, Lordship. The last occasion, I directed the Jila Parishad to file an opposition. No, a report. Lordship, we have received a report filed by the Jila Parishad. We shall prefer an exception to it, Lordship. May I file the report?
Report filed by
The Jila Parishad.
Birbhum Jila Parishad is taken on record.
এটা দিন গল্প করতেই হবে এটা দিন
You say the report, it is affidavit in opposition. What was it?
Lordship, this is actually a report. However, they have nomenclature it as affidavit in opposition.
But because opposition is this, because fact is this, the land which has been mentioned in the writ petition, it is completely a different land that they have mentioned.
Lordship, the report itself is bad because they have
Then
preferred
they
the report.
have to,
We shall come back with an exception, Lordship.
maybe, but fact
Time
is
may be
this,
given. We shall
that they have
opportunity may
given
be
a
given.
wrong information before this honorable
They
court.
have given
that
a
they
wrong
are-
report.
They are, BLP has given the report.
The report is wrong by PLR.
Then you find out.
So
You
we
go and
shall file the
you
exception.
can make an inquiry. What I will decide that. will
I am
be final.
submitting before the court that we are filing an exception. No hearing is being conducted right now. Sir.
It is a harassment.
Order dated
We are the one getting harassed.
2025.
Our land is in encroached.
So a direction was issued to file a report in the form of affidavit. However, the respondent number 4 seeks leave to file affidavit in opposition to the writ petition. Leave granted. Affidavit in opposition filed on behalf of respondent number 4 is taken on record. Copy served. Learned advocate for the petitioners seeks accommodation to file affidavit in reply to such affidavit in opposition. Let such affidavit in reply be filed within a period of 3 weeks
Mal.
of reopening of court after Puja vacation. Advance copy be served upon the learned advocates for the respondents. 3 সপ্তাহ পরে
Grateful.
3 weeks under the heading returnable motion.
Grateful, Lordship.
Grateful.
Yes.
Copy the বীরভূম জেলা পরিষদ থেকে? বীরভূম জেলা পরিষদ।
Madam, for the 523.
523.
523.
Yes, তাই তো বলছি।
তাই তো
523.
523.
The respondent number 8.
My lord, this is the matter report.
Madam, for the my lord,
5. Affidavit in opposition as per your lordship.
last in order to my lord, your lordship, kindly my lord, see the my lord, last day my lord, the order passed by your lordship, my lord, I am led by Mr. Subish Sannal, my lord, senior advocate, my lord, he is on legs. My lord, your lordship, kindly my lord, peruse your lordship's last order, my lord.
Approved 570 square feet. This below ground floor, the proposed building is
Application to
with regard to the first floor. Yes.
My lord, senior lordship, my lord, then your lordship, my lord, I have filed one application, my lord, can 1, my lord.
Sir.
Yes, I have served, my lord. This is my affidavit of service.
Supplementary affidavit.
Affidavit of service, my lord. দাদা একটু নিন না my lord, after your lordship's order,
কোথায় গেল? Can is checking. Can is listed. What is this can application?
yes, my lord, can 1 is listed, my lord. It is in the list.
The list আছে।
My lord, probably nowadays, my lord, it is listed by the computer, but physically, my lord, the copy has not, my lord, subject to correction.
So what is in the can application?
My lord, can, my lord, after your lordship's order, my lord, your lordship's order, my lord, the last occasion after hearing Mr. Sannal and my lord, the state advocates and my lord, the private respondent, your lordship's are specifically, my lord, direct, my lord, my learned friend, my lord, to my lord, come with an report. My lord, the allegation was, my lord, we have asked for the, my lord, 2 floor of the sanction, my lord. 1 is already, my lord, the given, my lord, the other is, my lord, that not given the pending, my lord, your lordship has recorded, was pleased to record, my lord, that the deemed sanction, my lord, we have shown your lordship the provision in the, my lord, from the manual. My lord, in the meantime, my lord, pending the of the writ petition, before filing of the, my lord, they have, my lord, issued 1, my lord, notice for demolition of the, my lord, the second, my lord, the first floor and the, my lord, the ground floor, the portion.
Sanction was for ground floor or first floor?
My lord, sanction was initially given the first floor.
Kindly,
first
Your
floor.
Lordship,
My lord, according to them,
come to page 17 of
my lord,
my
according to them,
report.
according to, I
She has
believe, my lord, I
admitted-
believe my learned senior friend will get.
She has admitted everything unauthorized.
I have not admitted anything, my lord.
Everything admitted.
My lord, SDO already passed order.
Everything admitted.
My lord, that I have challenged, my lord. My lord, in the pending of the writ petition, my lord, I have shown before your lordship, my lord, that what SDO is doing, my lord.
If Your Lordship kindly come page 17, it is her application, her
The
admission.
last occasion your lordship was pleased to direct, my lord, that I have to hear it out, the, my lord, the provision, and my lord, I will hear out the writ petition.
Yes,
Both
yes.
the writ petition, my lord, this and my lord, the
My
filed
lord,
by the private
Page-
respondent.
Page 17, my lord, I am reading, it is her application. আমি মাধবী রায় বয়স 65 বছর পত্রসায়ের ব্লকের বিউর বেতুর অঞ্চল পাটিত গ্রামে আমার পিত্রালয় আমি ওই গ্রামে আমিও আমার ছোট বোন সম্পা দুবের নামে একখণ্ড বাস্তু জমি ক্রয় করি 2017 তোমার অ্যাপ্লিকেশন বোন অববিবাহিত ও ক্যান্সার আক্রান্ত বোনের ভবিষ্যৎ ভাবিয়া ওই জমির উপর একটি ছোট দোতলা বাড়ি করায় 2018 সালে 55 অনুমতির আবেদন করি 2 তলার অনুমতি আবেদন করিয়া কেবলমাত্র 1 তলার জন্য অনুমতি পায় 1 তলাটি নির্মাণ করিবার সময় প্রয়োজন হেতু বাড়িটির এরিয়া একটু বেশি হইয়া যায় আমি বাড়ির নিয়ম কানুন কিছুই জানিতাম না এই বাড়ির অংশটুকুর জন্য পঞ্চায়েতের অনুমতির প্রয়োজন ইহা আমার জানা ছিল না কোভিড পরিস্থিতির সময় দোতলা নির্মাণ করায় তখন অনিয়মিত অফিসের জন্য অনুমতি চাহিয়া অনুমতি প্রাপ্ত হয় নাই তৎকালীন প্রধানের মৌখিক অনুমতি অনুসারে বাড়িটি সম্পন্ন করি পরে কোভিড পরিস্থিতি স্বাভাবিক হইলে প্রধান পরিবর্তন হয় এবং বারবার অনুমতি চাহিয়া অনুমতি পাই নাই এবং আমার আবেদন প্রধান অফিস গ্রহণ অস্বীকার করেন এমত অবস্থায় ওই গ্রামের বাসিন্দা সুকুমার দে আমার বাড়িটি বেআইনি করিয়াছি এই মর্মে হাইকোর্টে একটি মামলা দায়ের করেন সুকুমার দের বাড়ি আমার বাড়ি হইতে 200 ফুট দূরে অবস্থিত মামলায় অভিযোগ ছিল সুকুমারদের বাড়ি জমির উপর বাড়ি করা হয়েছে পীর বাবার উপর জমি বাড়ি হয়েছে পঞ্চায়েত রাস্তার উপর একটি বাড়ি রয়েছে পঞ্চায়েত হইতে কোনো অনুমতি নেওয়া হয় নাই মহামান্য হাইকোর্টের নির্দেশ অনুসারে নির্মাণ সহায়ক প্রধান বাড়িটির মাপ করিয়া স্কেচমেপ করেন একটি রিপোর্ট এক পাতা রিপোর্ট পাঠান সুকুমারদের সমস্ত অভিযোগ মিথ্যা প্রমাণিত হয় ওই রিপোর্টে দেখা যায় আমি আমার জমির উপর নিয়ম মেনেই বাড়ি করেছি কিন্তু মাপের স্কেচের রিপোর্টের সঙ্গে অসঙ্গতি দেখা যায় আমার অভিযোগপত্র প্রধান গ্রাহ্য করেন নাই লিখিত অভিযোগ গ্রহণ করতে অস্বীকার করেন আমার বাড়ির সপ্ত লেভেলে 608 স্কোয়ার ফুটের বেশি হইবে না বাড়ির দক্ষিণ প্রান্তে 3 ফুটের মতো ফাঁকা জমি রয়েছে তাছাড়া রেকর্ড অনুসারে জমির 1015 স্কোয়ার ফুট বাড়ির চারপাশে প্রায় 40% ফাঁকা জমি রয়েছে 8/8/2024 মহামান্য হাইকোর্ট এসডিও বিষ্ণুপুরকে বিষয়টি সমাধানের জন্য নির্দেশ প্রদান করেন আমার বিনীতক্রান্ত সব দিক বিচার করিয়া যথোপযুক্ত আইন ধার্য করিয়া আমার বাড়িটিকে আইনগত শুদ্ধ করিবার জন্য বিপদমুক্ত করুন there is no scope of prospective approval there is no scope of my lord giving the after the unauthorized construction
Not
under
post
the
facto
Panchayat-
approval, my lord. My lord, it is a my lord, deemed, my lord, your lordship has recorded, my lord, as per rule 30 of the West Bengal Panchayat rule, my lord, last order, your lordship, my lord, 2000.
there is no application in the prescribed form B, form 4 for sanction of the plan. If it is sanction plan with by depositing plan, I have showed my lord the form B, and there is an undertaking. I will not construct anything in the application. There no such application was ever made in anywhere. What is deemed application?
SDO already reached its finality.
Yes,
Already
yes,
got
yes.
passed.
Order passed.
And became infractuous the repetition by way of can application. They challenged order passed by the SDO. Already subdivisional officer.
My lord, if your lordship kindly see that
My lord, that was exactly recorded by your lordship in the last order.
your lordship, if your lordship can, yes, my lord, that is my lord page 566. For my lord, this is the prescribed form which to be applied. And no, at any point of time, such type of application has never been made by the petitioner. What is the provisions of only by submission of making from the bar deemed application, deemed sanction?
I am not making any submission from the bar. What is in the law, my lord, I am not making that.
Yes, that is the law. Is the law is that the application
This is
made
absolutely,
in
my lord,
purpose.
interference of justice, my lord. After your lordship's last order, and my lord, in the meantime, my lord, SDO, my lord, is superseding the High Court. My lord, your lordship has recorded it. It
There
was,
is no
my lord,
stay.
their presence.
There is no stay.
On the strength of the contempt application, SDO has passed the order.
There is no stay.
Prisoner was present in every day.
And twice the assistant engineer, they have measured the everything. All steps.
My
have
lord,
been
I
taken.
can show your lordship, I can demonstrate your lordship. They have come, my lord, for the measurement. My lord, one time
No,
they have
what
come
about
saying,
the-
my lord, this is the A. My lord,
What-
next time measurement is B, my
What
lord.
about the first floor? What about the first floor?
My, that is the, my lord, writ petition, my lord, the first floor, my lord. That is Rule 30, my lord.
Rule 30 without any application.
My opposition, my lord, I also
During the hearing, some application has been given to the SDO, and SDO is not the authority.
SDO is not the authority.
Yes,
Panchayat is the authority.
Panchayat is the authority. You have made the application to the SDO. And there is no such application for permission. And clause 7 is very much clear. I also hereby undertake I shall not start the construction work before receive permission from the Gram Panchayat.
ওরা যে স্টেট যে এফিডেভিটটা দিয়েছে রিপোর্টটা কোথায়?
Panchayat already detected that.
Yes.
রিপোর্টটা কোথায়?
Twice. Thereafter, the Pradhan was given the direction of the SDO. My lord, in my report, I have submitted, my lord, that the Pradhan was directed to give with sketch map what is the deviation, what is the violation, and my lord, during the course of hearing, he made application.
My lord, I specifically prayed in the writ petition, my lord, for my lord appointing one, my lord, person, my lord, who is not, my lord, either by the influence by the, my lord, Panchayat or, my lord, anybody. My lord, I cannot say anything, my lord, or everything in the open court, my lord, what is happening, my lord. My lord, everything can be, my lord, everything can be regularized. But your lordship knows everything. My lord, that I didn't do that. That is why, my lord.
This writ petition.
Under what provisions of law the regulation can
No,
be there?
my lord.
The order of the SDO, if you are agreed by that, challenge.
Yes, you have challenged that.
No, my lord, your lordship, my lord, kindly, your lordship, my lord, last order, your lordship, kindly see, my lord, I have filed this scan application to bring it before your lordship, to notice your lordship.
If you are agreed by the order of the SDO, you can challenge it.
My lord, your lordship, kindly, my lord, peruse, my lord, once your lordship's order, my lord, once your lordship, my lord, I
use that order.
My lord.
It is the submission of Mr. Sannal
My
which
lord.
has been recorded. It is not the observation or finding.
Absolutely, your lordship, absolutely. My lord, after that, my lord, your lordship asks, my lord, filed.
Sir, you cannot extend this writ petition. Since the order has been passed, that has to be challenged if you are aggrieved.
My lord.
That has to be challenged. Otherwise, how can this?
My lord, your lordship, kindly see the writ petition, my lord, kindly see my writ petition prayer. Your lordship wants prayer, my lord. Your lordship wants your lordship prayer. My lord, I believe, my lord, my learned friend will get, my lord. Your lordship, kindly see the, my lord. What is my writ petition? My lord, the writ petition is, my lord, what is SDO has passed? My lord, SDO has passed, my lord, the order, my lord, on the basis of the order passed by the, my lord, Panchayat, Pradhan of the Panchayat. My lord, I have questioned the order of the Panchayat. My lord, if the order of the Panchayat goes, my lord, then there is no existence of the, my lord, order of the SDO. Your lordship, kindly see the prayer of my writ petition once. My lord, may I read, my lord, your lordship, my lord, sir. My lord, prayer A. To quash the report prepared by the respondent number 6 in pursuance of such and such. My lord, it is expressly bad and contains erroneous details. The read mandamus, then, my lord, your lordship, rules for sanctioning the revised building plan by considering the construction to be deemed sanctioned. This is the writ petition, my lord. My learned friend cannot say this writ petition is infructuous today. But I have asked for.
Under what provisions of law deemed sanction can be granted?
Then, my lord, prayer C, prayer D, my lord. We have questioned this, my lord, order.
Which order?
My lord, the order passed by the Pradhan, my lord, saying that this is the illegal. My lord, that we have questioned, my lord. My lord, if I, my lord, draw your lordship attention of the order passed by the Pradhan, I can demonstrate, my lord, that the order is illegal, my lord. In the sketch, my lord, is one, my lord, in the report is another. Your lordship have annexed in the order, your lordship, my lord. Kindly see, my lord, the order, my lord.
Subdivisional officer,
My lord.
through junior engineer, has held as independent.
Your lordship appoint anyone. My lord, there are, my lord, the Amin of the, my lord, Calcutta High Court, my lord, engineer.
Getting the aspect.
My lord.
You have argued that on the basis of the report of respondent number 6, this order has been passed. The order says that the SDO has appointed a junior engineer to conduct a separate independent inquiry, which has been held.
My lord, that is.
Thereafter, it has verified with the report submitted by the Pradhan.
My lord, two
it
reports.
Is not that the order has been solely passed on the basis of report of the
My lord, that my lord, my humble submission, my lord. One hand, my lord, the Panchayat Pradhan, another hand, my lord, STO. My lord, if your lordship tallies both report, my lord, both reports are different, my lord, from each another, my lord. This, my lord, I have stated in the, my lord, the supplementary affidavit. Your lordship has also, my lord, considered the supplementary affidavit. We have annexed it, your lordship. Once, my lord, kindly see my supplementary affidavit. In the last occasion, we have filed it. Your lordship that considered, your lordship. That is why your lordship recorded the submission of Mr. Shanna.
What about the admission of
my lord, your lordship, kindly see.
construction? What about the admission of first floor construction unauthorized?
My lord, the supplementary affidavit I have filed, your lordship, kindly, my lord, see.
That their writ application became infructuous. If your lordship kindly see for their.
My lord, supplementary affidavit, your lordship, kindly once see.
And 9th that order taken first by the subdivision of the Calcutta district was passed in order to render the instant writ petition infructuous, thus causing gross prejudice in the interest of the applicant.
Supplementary affidavit, my lord, I am annexed. I am stated here in my lord, specifically that video has read this.
Paying for quashing the report prepared by the Pradhan. That is for my
lord, paragraph 3, my lord, I have written, my lord. Supplementary affidavit, paragraph 3.
You will not challenge the SDO's order. So we will restrict to respondent number 6. Now you are running the risk. If it is not challenged, I tell you once again.
No.
We will restrict your writ petition in respondent number 6.
My lord, I will challenge, my lord. No, my lord, I will challenge your lordship.
Your submissions with the prayers you have made in the writ petition. You are not concerned with what the order passed. Let's see what happens.
My lord, I will challenge the, my lord, your lordship.
How you will challenge? Sir, I am asking you that the thing, that there is an order on the face of it, staring at you. You don't challenge that order. You are restricting to respondent number 6. We will restrict to the prayer of respondent number what you have challenged, and we will see.
My lord, may I pray one thing?
Order exists then.
No, may I pray one thing?
That is the order you are agreed by. The order has been passed for demolition. The Pradhan has not passed for demolition.
My lord.
23.5. The
I got your
SDO now passing an order for demolition. If you don't challenge that, it will stare at you. Because you cannot go beyond the prayers made in the writ petition.
I got your lordship, my lord.
If you challenge the order of the SDO, then the entire aspect comes because it culminates in the order of the SDO.
My lord.
You are in the stage of Pradhan.
My lord.
So now it is you to decide what you will go. Either you continue with this or withdraw this with liberty to file a press with details. You come. You can do that. I can grant you liberty.
My lord, your lordship, do that, my lord.
Huh?
Do that, your lordship. My lord, give me, my lord, some time, my lord, to 1 week or 2 weeks, my lord, some time so that I can, my lord, question the, my lord, SDO order. In the meantime, my lord, let them not take any steps, my lord. At this moment, it's a household, my lord. I am residing with a cancer patient, my lord, so that I should not be, my lord. Only this much, your lordship. Nothing, my lord. I can demonstrate your hearing, your lordship. Your lordship, upon any officer, special officer of this honorable court, your lordship will find, my lord. Nothing engaged, nothing engaged.
But nothing will be improved in respect of the first floor, which is totally unauthorized.
State, my lord. State has, my lord. This is the reply, my lord.
So encroaching the PWD road.
No, not at all, my lord. Not at all, my lord. Not at all, my lord. I have given the photograph also, my lord. I have also photograph, my lord. Not at all. My reply, my lord, the private respondent has, my lord, the file, my lord, the affidavit to the writ petition, my lord, I have given reply.
But I have submitted the report of matter, and I have served it on 15th September.
Mr. What is your name, sir?
My name is Ratul Biswal, my lord, led by Mr. Sannal, my lord. My lord, he is just on legs, that is why.
For the petitioner submits that the subdivisional officer during the pendency of the writ petition has passed an order of demolition.
দিলাম তো আমি দিটো আচ্ছা দে
which requires to be challenged by way of a requires to be challenged. Seeks to withdraw this writ petition with with liberty to file afresh. In view of such submissions, the writ petition is dismissed as withdrawn with liberty to file afresh. Which is the order dated? What is the order dated you intend to challenge?
My lord, exactly, my lord, the order cannot read, my lord, in my copy.
That dated that is
1st September 2025. 1st September.
what 5 of my opponent.
Which for?
8,000.
6/8.
No, not 6/6.
SDO has put the order on 6th August.
No. 1st September 2025.
1st September, subject to correction, my lord.
1st September 2025. Huh? We already challenged for 1st September 2025.
Passed by the SDO.
Oh,
Issued by the SDO.
SDO. Yes.
Affidavits will, report filed by the state is taken on record. Affidavit in opposition filed on behalf of respondent is taken on record. Affidavit and reply filed by the petition also taken on record.
My lord, one thing, my lord, subject to correction, my lord. My lord, Puja is intervening, my lord. In the meantime, your lordship kindly.
Before the vacation, bench, sir, I need not advise you.
No.
6 weeks time for self demolition. Thereafter, notice will be given to you.
Yes.
There is time. You have not gone through the order.
My lord, the order is not, my lord, legible.
I have gone through the order. You can have a look to the order that has been annexed to the affidavit in opposition.
May I pray one, my lord, the
Copy has been annexed. It's page 46 of the affidavit in opposition.
Report in the form of report in the form
Sir,
of
I tell you, it is
affidavit
6 weeks. Thereafter, block development officer will take steps. So you have time.
Humble prayer people will see my the state respondent already filed a report. That was not delivered to me. My kindly one day
একটা কবি নিবি?
The report was not handed.
Give a copy of reports and all have been given to you.
Report, my lord.
Give a copy to the private responder.
Grateful, my lord.
Yes, yes. Thank you.
September থেকে 6 সপ্তাহ মানে 15th October. No, the 6 weeks starts from 1st September. Malad, it ends with Malad 15th October. Then Malad, we will be in Malad.
How many vacations are there in between?
4 vacation, Malad. Grateful, Malad.
Deep level.
Item number 524, my lord, I am for the petitioner.
My lord, in this matter, my lord, I beg to appear on behalf of the state, my lord. My lord, the today list, my lord, list, the brief is, my lord, is not with me, my lord. Tomorrow, my lord.
Tomorrow I may not be taking up return motion. Only top motions will be taken. What is the matter?
Huh?
Oh, আমি তো করবো, আমি ready আছি। My lord, I am ready, my lord.
What is the matter? Yeah,
My lord, I am for the petitioner, my lord. My lord, this is renewal application. My petitioner was Anganwadi worker. Well, as per the notification, my lord, Madhyamik pass qualification, my lord, was required for appointment of the Anganwadi worker. My lord, graduates were not eligible, and if anyone, my lord, suppresses. No, copy nahi, sir. Graduates were not eligible, my lord, and if anyone suppresses graduation, will be terminated. That was notified, my lord. My petitioner and some other, my lord, suppressing their graduation, got the service and afterward terminated, my lord. Petitioner prayed for reinstatement before this honorable court, but her prayer was rejected.
Come tomorrow. Tomorrow, Mr. Mahata. Come tomorrow.
My lord.
You actually returnable রাখবে দেখ।
Tomorrow, কালকে থাকবে?
Tomorrow. My lord.
Grateful, my lord.
For the petition.
520.
My lord, kindly have a look, my lord, last order passed by Justice Kapoor. Mr. Mahato, my lord, my esteemed senior friend is appearing on behalf of the state. Forester. 525.
Yes, sir. বৃষ্টির জন্য যায়নি চেম্বারে আর
কালকে করো
চেম্বারে যায়নি তো কালকে
After the vacation. What is the matter, Rioni?
My lord, this relates to, my lord, the petitioners were engaged, my lord, as a tubewell operator. They were given, my lord, the proper training. Video asked the Pradhan to engage. We engaged. Thereafter, my lord, 2007 we are working. All on a sudden, the Pradhan obstructed me, my lord, not to join, not to work. This is the matter. Now, my lord, the similar question, my lord, has came up before this honorable court, before Justice Honorable Division Bench presided over, my lord, Justice Pranab Kumar Chattopadhyay, as his lordship then was. My lord, if Mr. Mahato, my lord, he is, my lord, very cooperative. He is today in difficulty, my lord. Let it be taken up tomorrow, my lord. I shall finish this. Because he has sought for the instruction.
Due to the evidence, clerk did not attend my chamber tomorrow. Yesterday, my lord, my clerk did not attend my chamber.
Kindly text it up.
After the vacation, reopening.
My lord, kindly fix a date, my lord, in that event, my lord.
Mr. Mahata, learned advocate, additional government pleader seeks accommodation. Place this matter on 27th.
My lord, in the meantime, Mr. Mahato be directed to take instruction as he was sought for in the last order.
State is that. Was there any direction to file report?
Not report, my lord. Only Mr. Mahato sought for, my lord, instruction.
Decided to furnish the report in the form of affidavit on the returnable date.
My lord. My lord, in the report in the form of affidavit, my lord, then my lord, 1 week after vacation. because
One
my
week
lord,
after vacation কি date কি হচ্ছে দেখো তো?
দেখুন ডেটটা দেখুন একটু
By the returnable date 1 week after 4th November.
4th now deeply
my
দেখো
তোমাকে তো করে দিলাম আজকে তো
কি
টিপের ঘরে ওটা সুজয় পাল জিতে গেছে তো
না জিতেনি এই নামটা জিতেনি ও মোটামুটি যে অর্ডার দিয়েছে আমি এখন করে
526 লিফটে আছে তো
I am filing my exception, my lord, as per my lord's order.
আমাকে দিয়েছো কপি এক্সেপশন দিয়েছো
হ্যাঁ দিয়েছি, আমরা কপি দিয়েছি তো। এই তো, এই দেখুন রিসিভ করেছি।
এক্সেপশনটা কোথায়
এই দেখুন, এই যে,
এই এলাও
এই যে,
এই তো
এক্সেপশন কোথায়
নেই এর মধ্যে নেই
কোথায়
এইটাই তো
I'll kindly come to page 5, my lord, of my exceptions. A report of the block development officer, wherein it has been stated that my house in a Pakka house. I have annexed the photograph of my house, my lord. I have only 1.4 decimal of land. Moreover, my lord, page 10 of my exception, my lord, the earlier a panel was prepared, wherein my name was found in the list of the beneficiaries.
Page number Lalu.
It was stated in the report that my house is a Pakka house, but my house is not a Pakka house. I am only owner of a 1.4 decimal of land, and my house is, I have annexed a photograph of my house. And earlier a list was prepared, wherein my name was there, my lord. Page 10, serial number 332. Page 10, feet 32. But my name has been excluded in the present list.
Where is the other names?
Page 32, my lord. Page 10, serial number.
Which list is this? Who has prepared this? Which authority has prepared this list?
No, I have not prepared.
Who
It
has
was prepared earlier by the authority of the Panchayat.
Where is that?
see my lord this is the executive officer of the concerned
Panchayat.
And my lord 332 it is here it has been
It is.
his
My name was there.
but his it has recommended the my lord it is he is ineligible for Pakka house. That is the report.
I have no Pakka house, my lord.
This is the report.
report
My lord, he
Page 43, annexure T2. This has been obtained from which place? Which office?
My exceptions, my lord. My exception, page 10.
Read petition, page 43.
No.
Lalu Khan, serial number 234.
Yes, my lord.
No, this page has been obtained from which website or which office? Which
My
is-
lord, it is a part of, I have annexed the same
in my affidavit in exception, my lord, page 10. Page 10. Yes. Just now I find. Yes, my page 10. 332. 332. Yes. T32, my. It was prepared by executive assistant and executive officer of the concerned. But my name has been excluded.
Why?
And on the ground that I have a Pakka house. But I have no Pakka house, but I am the owner of only 1.4 decimal of land. The report filed by the state administration is not a true one, my lord, on the basis of a true fact.
And where is your earlier, you say that you have been earlierly listed? Your name was there in the list earlier? Earlier your name was there in the list?
Is my page 10, my lord. No, page 10 is the present. No.
Earlier.
It is earlier list, my lord. Page 10. Page 10, it is ineligible. No, I have given. It is ineligible.
No, ineligible.
It is ineligible. 332, my lord.
332.
Ineligible. জিয়াদ খান ineligible পাক্কা হাউস। এই তো আমি হ্যাঁ তো এখানে তো ineligible লেখা আছে তো। Ineligible? এই তো ineligible পাক্কা হাউস। No, I have no pakka house.
But you have relied on this list.
You are relying on this list.
It is found that he lives in a Pakka house.
Yes, ineligible and pakka house. Well, I have given a photograph of my house, my lord.
That you can give photographs will not.
And I have made an application under right
What
to
did you
information seeking some information. At page 11.
This is annexure. Where is your report? Where is your report?
I love my read petition page 43, my lord. No. Yes. আমি যেটা রিপোর্টটা সাবমিট করেছি আমাদের রিপোর্টটা লালু খান এটা আর্লিয়ার রিড পিটিশন page 43, my lord, my read petition, where the serial number 234, my name is there, my.
Report, Mr. Mata?
Page 30,
Report?
40. It was only the report submitted by the block development officer, not in the form of affidavit. And that is also disclosure to the same thing. That is the report by the block development officer, and which he has relied upon the same thing. That is in page
by the present writ petition.
332, it is ineligible Pakka house.
The petitioner seeks for direction upon the respondent authorities to enlist the name of the petitioner as beneficiary for allotment of housing under the Pradhan Mantri Awas Yojana - Gramin. In short, PMAY-G, and consider the representation of the petitioner, Annexure C. The petitioner contains that he has a mud-built dilapidated dwelling house over a piece of land owned by him. A list was the local Gram Panchayat prepared a list of beneficiaries under the PMAYG, examining all necessary documents for the said purpose. The name of the petitioner was listed for allotting householding. However, his name has not been listed in the subsequent list. The petitioner made a representation before the block development officer, respond number 2, and the district magistrate, respond number 3, for redressal of his grievance. However, no steps have been taken, hence this writ petition. Mr. So and so, an advocate for the petitioner, submits that the petitioner does not have any pakka house. Exception to the report filed by the petition is taken on record. He seeks for relegating the matter to the authority concerned for considering the representation of the Mr. Lolit Mohan Mahatal, an additional government leader for the state, submits that the list prepared by the executive officer to show that the petitioner is having a pakka house. Seeks for dismissal of the writ petition.
Opposition টা দেয়া
Upon
হয়েছে
perusal of the report of the state, it is found that the report, the list annexed to the list prepared by executive assistant and executive officer, executive assistant Nandapur Maraguni GP and executive officer Chandipur Panchayat Samiti, serial number 332, shows that the petitioner Lalu Khan is held to be ineligible since he is having a pakka house. The said list has also been relied upon by the petitioner in its exception. Therefore, it is found that there is no merit in the writ petition. Accordingly, it is dismissed.
Before writing, my lord, may I be permitted to mention in regard to 530? My senior learned friend is appearing in this matter for this. He could not file the reply. He is playing after vacation, my lord. I have 1 week after vacation in the mean.
My lord, will go after the vacation.
530.
Next matter is fine. But I think for after that.
Item number 530.
So vacation পরে দিয়ে
My lord,
after vacation return
my lord,
যে কটা আছে ব্যাস ওই কটা থাকবে।
my lord, 533, my lord, I'm
Thursday is lordship original side, Friday to
Tomorrow
5 to 7. Next matter.
it will be listed after the vacation.
my lord, item number 533, my lord, I'm praying, my lord, if it can be taken up before vacation, my lord, if lordship recollects, my lord, this is a matter where it was my admitted dues are there and the Gram Panchayat was directed. My lord, they have filed their affidavits, my lord, if it can be taken up, my lord.
Cannot be.
But if it could be disposed of, lordship, before the vacation.
Not possible.
Well, then upon reopening, at least, my lord, let it come at the top of the list, my lord, for returnable. It has been in the list, my lord, for not 533. Huh? হ্যাঁ না টপে আছে না আইটেম নাম্বার 10 এ আসছে এফেক্টিভলি তো টপে করে দাও
The ID was on the other side.
yes my lord they have completed everything is over my lord if lordship can just take it up and dispose it of upon reopening yes my lord
There is no
yes my lord my admitted dues and they have to একটা my lord if it can be taken up at least upon reopening I will give the item the case number my lord to your lordship's officers
ঠিক আছে তুমি
হ্যাঁ
দেখো
উনি আছে
27 এরকম দেখে নাও একদম ফার্স্ট
হ্যাঁ।
দিয়ে দাও নভেম্বরের এতে give a notice to the others.
Yes, my lord, I shall do, my lord. Grateful, my lord. Grateful.